Welcome back to the Constitutional Clarion. This video is about proposals to reduce the voting age to 16 and the constitutional and legal history of changes in the voting age in Australia. It's not well known that the minimum voting age has changed from time to time, particularly during times of war. The current push for lowering the voting age in part reflects developments in other countries. In the United Kingdom, the Starmer Labor government recently announced that it will lower the voting age to 16 for elections to the Westminster Parliament. In some parts of the United Kingdom, the voting age is already 16 for certain elections, such as elections to the Scottish and Welsh parliaments. In New Zealand, in a case called Make It 16 Incorporated and the Attorney General from 2022, the Supreme Court held that the provisions of the Electoral Act which provide for a minimum voting age of 18 are inconsistent with the right in Section 19 of the New Zealand Bill of Rights Act 1990 to be free from discrimination on the basis of age. This didn't actually make the law invalid. What it does is it pushes it back towards Parliament for it to reconsider. So far, the New Zealand Parliament has chosen not to amend the law and the minimum voting age remains 18. To make that change, it would need either the support of a special majority of 75% of members of Parliament or the support of a majority of the people in a referendum, although there are legal arguments about whether that manner and form constraint is effective. See my previous videos on manner and form. The current New Zealand government, however, does not support such a change to the minimum voting age. In Australia, bills have been introduced from time to time by the Greens and Independents to reduce the voting age to 16, but they have not been supported by the major parties and have failed to progress. Many people probably assume that the right to vote is expressly included in the Commonwealth Constitution, but it's not. At the time the Constitution was being drafted, the enfranchisement of women was a hot political issue. Some of the colonies supported it and others didn't. To avoid this dispute derailing federation, compromises were made. The Constitution set as the initial franchise the existing franchises for the lower house in each state, but then allowed the new Commonwealth Parliament to enact its own franchise. And that's in sections 8 and 30 of the Constitution. But to protect the existing rights of women and also Aboriginal people to vote, for example, in South Australia, Section 41 was inserted in the Constitution. It said that no adult person who has or requires the right to vote in state elections shall be prevented by any federal law from voting in federal elections. Who is an adult person? Does it depend on what people thought at the time the Constitution was enacted, or does it depend on what people think now? In 1900, an adult person was someone who was 21 years of age or older. That was the minimum voting age set in each colony. It was also the minimum voting age set by the Commonwealth Parliament when it enacted its first franchise law in 1902. One factor that has affected views about the minimum voting age is war. If people can be sent to fight and perhaps die for Australia at the age of 18, it seems unfair if they can't vote to elect the government whose policies require them to serve. This point was made during World War I. As a consequence, Section 39, subsection 2 of the Commonwealth Electoral Act 1918 gave all current and former members of the armed forces who were British subjects and lived in Australia for the previous 6 months the right to vote in Commonwealth elections regardless of their age. But this provision had a time limit. It only lasted until 3 years after the end of the war. Then the minimum age went back to 21. The same problem arose again during World War II. The Commonwealth Electoral Wartime Act 1943 allowed serving and discharged members of the Defence Forces who were under 21 to vote in federal elections if they had served or were serving outside Australia during the war. In the 1960s, 20-year-olds could be conscripted into national service. they could also be sent to fight in Vietnam. Again, it was argued that if this was so, they should also have the right to vote. Section 39 capital A of the Commonwealth Electoral Act 1966 was passed to give members of the Defence Force who were involved in active service overseas in Southeast Asia the right to vote, even if they were under 21. But this did not extend to other National Service conscripts who served within Australia. The Labor Party tried and failed in 1968, 1971 and 1972 to get the federal voting age lowered to 18. Some saw their campaign as being about political advantage, as young people are more likely to vote Labor. Others saw it as a matter of fairness. If 18-year-olds can engage in other adult activities such as working full-time, paying taxes, marrying and joining the armed services, then that meant they should also have the right to vote. At the state level, the voting age was lowered to 18 in New South Wales and Western Australia in 1970. South Australia lowered the voting age to 18 in 1971. In 1972, 3 South Australians who were between 18 and 20 years old then applied to be enrolled on the Commonwealth's electoral roll. One of them was Susan King, who was the daughter of the South Australian Attorney General. Their applications were rejected and they challenged this in the High Court. They argued that Section 41 of the Constitution protected their right to vote at the federal level because they had a right to vote at the state level. Ms. King was represented in the High Court by Lionel Murphy, who was soon to become the Attorney General of the Commonwealth at the next election and later a High Court judge. Section 41 of the Constitution applies to an adult person. So it was necessary for Ms. King to convince the High Court to interpret adult person as including an 18-year-old. Murphy argued on her behalf that adult person means a mature person and that in 1972, an 18-year-old South Australian fitted that description. He said that 18-year-olds could marry, they could be convicted of criminal offences and sentenced to death under the then Commonwealth law, and could be required to serve in the armed forces. He presented evidence to the court to show that 18-year-olds are accepted in the community as adults. The High Court, in the case of King and Jones, rejected the argument that Section 41 applied to 18-year-olds. It looked to the historic meaning of adult at the time the Constitution was enacted in 1900. It then meant a person who was 21 years or older. The justices pointed out that the word was intended to have a certain meaning that would apply uniformly across the country, not a meaning that could be changed by any state. They did not consider it appropriate to change its meaning in the same way as community views have changed, as they consider that the word was chosen to achieve stability and certainty. There had previously been a debate about whether Section 41 of the Constitution should be interpreted narrowly, so that it only protected the rights of people who had been enrolled to vote before the Commonwealth passed its own franchise law in 1902, or whether it should be interpreted broadly so that it protected the rights of anyone who had a right to vote and who might have acquired that right to vote more recently. As Susan King had obtained the right to vote well after 1902, Section 41 would only be relevant to her if the broad view was taken. But the court found that it wasn't necessary to decide upon which approach to take because it decided that she was not an adult. In 1983, in the case of the Crown against Pearson ex parte Sipka, the High Court took the narrow view of Section 41. This means that it no longer protects voting rights because all the people who were enrolled to vote before 1902 are now dead. And that means that Section 41 is dead too. While Susan King lost her case, the Labor Party was soon elected to power at the Commonwealth level and in 1973 managed to get legislation passed to lower the voting age to 18. Now the push is on to lower the voting age to 16 with the same kinds of arguments being made. If 16 and 17-year-olds can hold down jobs and be required to pay tax, then it's argued that they should be able to vote too. The old "no taxation without representation" slogan is raised. But arguments that 16 and 17-year-olds can marry and join the armed forces are undermined by the fact that you still need parental consent for that. It would also be somewhat illogical if we, on the one hand, legislate to prevent under 16s from accessing social media on the grounds that they're too immature to deal with its harmful content, yet at the same time decide that they are mature enough to vote the instant they turn 16 and emerge from their sheltered digital world. One argument put in favour of lowering the minimum voting age is that decisions made at elections now, particularly on matters such as climate change, are likely to have a more profound effect on the lives of young people. They should therefore have a say in decisions that will seriously affect their lives in future decades, unlike older voters who will not live to bear the burdens of some of the decisions being made today. In other countries, it's commonly claimed that lowering the voting age will increase public engagement with elections. In Australia, however, we have compulsory voting. This leads to a dilemma. Do you compel 16-year-olds to vote, even when many of them will have no knowledge about political matters or any interest in voting? Or do you make voting voluntary for 16 and 17-year-olds? Does making it voluntary undermine the compulsory voting system overall? Because, of course, ignorance and lack of interest is not confined to young people. Would making voting compulsory for 16 and 17-year-olds put the onus on schools to take civics seriously and teach it properly in schools so that students were well equipped to vote? Maybe the prospect of voting might also make students take it seriously too, instead of seeing it as some kind of theoretical and irrelevant subject, or a bludge subject, as it was often called in the past. Some have argued that voting is not just a right, but a responsibility. And if it becomes voluntary for 16 and 17-year-olds, it unbalances that relationship with responsibility. Others have expressed the concern that voluntary voting for 16 and 17-year-olds would dilute the political influence of young people and result in demographic distortions, with those from affluent families more likely to vote than those from disadvantaged backgrounds. On the other hand, it's also argued that lowering the voting age is a form of partisan manipulation because younger people tend to vote for the left of centre parties. According to a UK House of Commons Library briefing paper on the subject, quote, "In the few countries where voting age has been lowered to 16, research has shown that there has been no impact on the result of elections," unquote. That statement rather surprised me, but I suppose one important factor would be that in the relevant countries there would have been no compulsory voting, so a smaller proportion of young people would have actually voted. In the United Kingdom, a study by the Joseph Rowntree Reform Trust pointed out that if 16 and 17-year-olds were given the vote, they would constitute 2.87% of the voting population, and their inclusion would have a negligible impact on overall vote shares, even in the most extreme and improbable scenario that all 16 and 17-year-olds turned out to vote and decided to vote in the same way. This may also be affected by first-past-the-post voting system, which is used in the United Kingdom, which is of course quite different to Australia's preferential system. What do Australians think about lowering the voting age? The Australian Electoral Study has been asking a question about lowering the voting age to 16 for some years. It shows consistently low support for the idea. For example, in 2022, only 14% supported lowering the voting age to 16, while 86% said it should remain at 18. While a lot of noise is made about the issue, it does not seem to have much grassroots support, at least yet. The final point to make here is that there could be a constitutional ramification if the franchise was expanded to include 16 and 17-year-olds. The High Court, in the cases of Roach in 2007 and Roe in 2010 suggested that there is a one-way evolution of the franchise towards the maximisation of participation. If it stuck with that approach, which is debatable, and a law passed when one side was in government enfranchising 16 and 17-year-olds, and then the other side on winning government sought to undo that law, there could well be a constitutional fight about whether Parliament has the power to contract the franchise once it has been expanded. It would also be quite hard from a political point of view to go back once the step was taken, which is why it should only be taken after being given proper consideration. Thank you once again for watching the Constitutional Clarion. I hope this video provides some food for thought, along with an interesting historical context. And, as always, I look forward to seeing you again next time. Goodbye.